started, but okay, we have our recording in progress. We have also closed captioning enabled for this program if you need it. And also this presentation will be recorded. We will circulate the PowerPoint and a more detailed handout after the presentation. And we also, for those of you who are attorneys, we will also circulate an MCLE certificate if you've requested it before. We have the ability to take questions through the Q&A if you'd like to send us a question. So please feel free to use that, and we will either answer your questions during the presentation or can follow up with you afterwards. We also have Elena Jack with us here who can help you with any technical issues if you're having problem hearing us or logging in. So just to follow up again, my name is Arlene Yang. I am a principal at Myers-Nave in the Labor and Employment Group. Myers-Nave is a law firm that helps clients to resolve very complex and high priority transactions, litigation, and regulatory compliance matters. We have, I specialize in providing advice and counsel to employers, conducting internal investigations and litigation in state and federal court. I have with us today some fabulous presenters that I work with. Let's start first off with Corinne Johnson.
Hello, everyone. As Arlene said, my name is Corinne Johnson. I'm a senior associate in our San Diego office, and I also do advice and counsel for businesses in litigation. I also advise on handbooks and policies and conduct internal investigations.
And we have Alicia Morel.
Hi, everyone. My name is Alicia Morel, and I'm a senior associate up in the Oakland office where I conduct investigations and do a lot of workplace training, and then also focus on areas and matters of environmental health and safety.
And Neha Shah.
Hi, everyone. My name is Neha Shah. I'm a senior associate in the Oakland office, and my practice is largely focused on traditional labor relations. That's the relationship between union and management, but I also do workplace investigations, training, and advice and counsel.
And Alex Cat.
Hi, everyone. My name is Alex. I'm an associate in our San Diego office, and I just do general litigation and workplace investigations.
Great. So as we have as usual, California employers have to be on their toes. There are always so many changes to employment law every year. We wanted to find out from you what you're most worried about in 2023. So we have a little poll, and I think you should get a polling device. So please let us know what's most concerning to you right now. And while we're waiting for our poll numbers, that we can just kind of give you a little bit of a preview about what we're going to be talking about today. Just as this is intended to be a informational presentation, and we're not providing legal advice on any particular issues, but you should consult with counsel. Our agenda today includes looking at California minimum wage and pay transparency issues, an update on COVID-19, looking at leaves, benefits, and accommodations, privacy issues in the California new privacy laws that apply to employers, arbitration updates, labor relations, and looking at equity in the workplace. And we will try to leave some time for questions, but if you have questions along the way, please let us know. And looking at the top, okay, so we have number one as new leave laws, 37%. We have questions about pay transparency and a little bit of everything else. So we're looking forward to helping to answer some of your questions. So moving right along, we'll move right to the California minimum wage increase with Alicia.
Let's talk about money. So a new minimum wage went into place for all employers, regardless of size, on January 1st. As of that day, the minimum wage in California is $15.15 per hour. Originally, the wage was going to be $15 flat for employers with 25 or fewer employees, but the annual inflation adjustment kicked in and that brought everyone up to $15.50. What you need to know is that this increase impacts the salary standard for exempt employees who are required to make no less than 2 times the state minimum wage. So that means that exempt employees, regardless of whether or not they're full or part-time, need to be paid a minimum annual salary of no less than $64,480. Additionally, we want you to keep in mind that there may be local city or county minimum wage regulations that might bring that minimum wage up even further. So for example, San Jose has $17 an hour and the city of San Diego is at $16.30. Ultimately, the takeaway here is that you need to make sure that your minimum wage payments and also your postings are updated to reflect state and local increases. And please ensure that your full-time and part-time exempt employees are being properly paid. So now moving forward and thinking about pay transparency, which great news, a lot of you are interested in, we have a couple of different things that impact our private employers that we'll talk about. So first of all, with respect to job postings, in order to address wage disparities at the beginning of employment, all employers with 15 or more employees must follow the new wage disclosure requirements for job postings. Now, this applies to employers with at least 1 employee based in California, regardless of the location of that company's headquarters. And the requirement also kicks in if the position may ever be filled in California, either remotely or in person. Covered employers must include a pay scale with their job postings, and this includes third-party postings used by employers. So LinkedIn or Indeed or using a headhunter means that obligation will also carry over. So you're going to need to provide LinkedIn, Indeed, or a headhunter, for example, with the pay scale information so that they can use it in their advertising materials. Now, the definition of pay scale in this law right now, as it stands, is very broad and open to your interpretation. Pay scale is defined as the salary or hourly wage range that the employer reasonably expects to pay for the position. This does not include bonuses, commissions, health benefits, or paid time off. But if the position's hourly or salary wage is based off of a piece rate commission, then that piece rate or commission range that you reasonably expect to pay for the position must be included in the posting. Additionally, what this means is that you also have an obligation to provide current employees with pay scale information or with their pay scale information for their current position upon their request. You may have already had some employees who have requested this information, but if not, you can probably expect to see some requests from current employees at some point in time. We don't yet know what the timeline is with respect to how long you have to provide that information, but if they ask, you have to respond with their pay scale information. Additionally, there is a record retention requirement that's now in place. Under this law, you must abide by a record retention requirement that enforces an obligation for you to maintain a record of each individual employee's job title and wage history during their employment, and then also for 3 years after they have left the organization, been terminated, or have departed on their own. And these records need to be made available to the labor commissioner for inspection to determine if there is a pattern of wage discrepancy. Your failure to keep these records creates a rebuttable presumption in favor of any employee's claim that there actually is a wage discrepancy problem within the organization. And additionally, or in addition to a rebuttable presumption, there are other methods of enforcement with respect to this new law that includes civil penalties of up to $10,000 per violation. However, I will say that the first penalty will not be assessed if you can demonstrate that you have cured the job posting by updating it to include pay scale. So you're going to want to make sure that you pay attention to that. In addition, there is a new obligation to provide a pay data report for all private employers with 100 or more employees. This is an annual report that is filed with the Civil Rights Department and discloses certain pay data according to race, ethnicity, and gender within each of the following job categories. And there's, I think, 10 of them. They include executive or senior level, technicians, operatives, laborers, and helpers. The handout that you'll receive following this presentation will include a list of all of the job categories that you will need to have this pay data for. The information must be disclosed with respect to things like number of employees by race. Within your job categories, you need to have the mean and median hourly rate. There's just a lot of information that's included in this report. And staffing companies are included. So if you have 100 or more employees and some of them are hired through labor contractors in the prior calendar year, you'll also need to submit a separate pay data report covering labor contractors. For this year, that pay data report is due on May 10th. And in the years ahead, it will be due on the second Wednesday of May. And that report will be filed through the California Pay Data Reporting Portal. So the takeaway is ultimately for the pay data information, and I know that that has been somewhat brief, but we'll give you a lot more information in the handout, and to the extent that you have additional questions, please reach out. But one, please be preparing pay scales for any new posting that you are doing basically from here on out, as that information needs to be included across the board. And also develop a system to ensure that postings include your pay scale. So some sort of an audit or a double check, especially right now when that obligation is new. Additionally, you want to be preparing pay scales for all of your positions, as your employees may start requesting that as early as January 1st. So that might be something that you're already getting. You'll want to develop a system to respond to employee requests in a timely fashion. I don't think that you have to have that information within the hour, but I also don't think that you can take weeks to get employees that information. Additionally, you'll need to develop a plan for saving data and adhering to the retention schedule that this pay data law requires. With respect to the pay data report, please make sure that you have a system in place to have your report done, dusted, and filed by May 23rd of this year, and then the second Wednesday of May every year moving forward. And one of the major things I think for all of this information that I've just shared is that now is a good time to consider whether or not you would like to hire your favorite Myers-Nave attorney to conduct a attorney-client privileged pay equity audit to see if the data is going to suggest that you might need to make some adjustments to increase or achieve pay equity within your ranks. So that is it. Oh, go ahead.
Oh, we had a question actually.
Yeah.
So how about maintaining records? Is that just for employers with 15 or more employees, or for all employers?
I believe that is all employers.
Yeah, that's my understanding as well.
Yeah, so that, and I mean, it's not a light lift. We understand that is a significant request, but a request, or not even really a request, a requirement nonetheless. And so if you do need help kind of developing these new systems, reach out. That's something that we can help put together for you.
Yeah, I mean, I think that's just generally a good practice anyway. When someone's getting a promotion and their salary's increased, often employers will put something into their personnel file that demonstrates what the new title is, what the new wage is, and then if there's, that can be helpful later down the line if there's any disputes.
Yeah.
And another question was, does this apply to nonprofits?
Yes.
Mm-hmm.
So let's shift very briefly to talk about COVID for a second. So there is a extended obligation for COVID notice. Most things were set to expire at the end of 2022, and many things have been currently extended through January 1st of 2024. The COVID exposure notice was significantly altered most recently, and employers now may either provide a written notification or a worksite posting of potential COVID-19 exposure. If you're going to be using the posting option, you must, within 1 business day of notice of a potential exposure, prominently display a notice in all places where notices to employees concerning workplace rules or regulations are customarily posted. And that includes, if you use a portal, you may post there. When you receive the notice of a possible workplace exposure through a positive employee, you'll need to place that notice prominently, and it needs to include things like the dates that that employee was on the work site or at the work site within the infectious period, the location of that employee with specificity, and then some information on both COVID-related benefits within the organization and information about cleaning protocols and prevention of COVID spread in the workplace. And that posting, if you're going to be using that method, that posting needs to stay up for 15 calendar days. If you're going to be using a written notice, it just needs to be provided to all employees and the employers of subcontracted employees who were at the same work site location as the individual who tested positive. And that can be provided via personal service, email, or even text. So the takeaways there really are make sure that you have kind of a protocol for posting or a protocol for noticing your employees as soon as you get wind of a positive employee. But you do have kind of a tight turnaround unless it happens on a Friday, and then you've got the weekend to figure out that posting. But otherwise, it does need to go up that very next workday. So then very quickly, just a little bit of information regarding the extension of workers' compensation. There has been, up to this point, a rebuttable presumption that under certain circumstances, COVID-related illnesses were presumed to be work-related for the purposes of awarding workers' compensation benefits. Those presumptions were set to expire. They have been extended. Additionally, I mean, really, that's kind of what you need to know, is that you just need to make sure that HR staff and whoever kind of is in charge of and responsible for workers' comp related benefits at your work sites and within your organization remembers and keeps in mind that COVID may still be compensable under workers' compensation. And please just maintain encouraging your employees to report workplace infections. That keeps everyone safe, or more likely to be safe, just kind of across the board. So that is that for me. And I am now going to be passing things on to Corinne.
Actually, I'm going to jump in here real
Oh,
quick.
take it, Alex.
I have a question for Alicia. One is, if the employee's working from home and gets COVID and they don't come into the office, does that protocol have to be followed?
So if they are a full-time remote worker and they were never on the job site, then the posting requirement would not kick in, because that would not have been necessarily a workplace exposure that other employees need to be noticed about. However, the employee should still notice you as employers, because there are COVID-related benefits that they probably will need to be informed about, that you'll want to make sure that they are aware of.
Right, and I'm not sure if you know the answer offhand. We could follow up. If the email notice is sent, do you have to post it for 15 days, or is email enough?
That email notice should be sufficient. However, it needs to be broad enough that everyone who is potentially exposed is on notice. So I don't think it's a bad idea to pick up the practice of doing the posting. However, I will add, since I didn't originally, that if you do the posting method, you will need to keep and maintain a log of the dates in which that posting was up. And that might be something that Cal OSHA, should they come knocking, seek to inspect.
Great, Thank you.
Yeah.
Keeping on the topic of COVID, just to kind of close things out. So we were under emergency regulations, but the California Occupational Safety and Health Standards Board recently voted to adopt non-emergency COVID-19 prevention regulations. And these regulations will take effect once they're approved by the Office of Administrative Law, should be sometime this month, and will remain in effect for 2 years once those become effective. Many of those emergency standards still apply, such as providing masks in the workplace, testing supplies, things like that. However, a big change was that employers are no longer required to maintain a standalone COVID-19 prevention plan, and instead, COVID-19 can be considered a workplace hazard and should be included in your written injury and illness prevention plan, or your IIPP. So a couple important definitions changed according to these regulations, such as close contact. Now, when you're looking at that, it's defined by looking at the size of the workplace in which the exposure takes place during an infectious period. And a key detail is that offices, rooms, or other spaces that are separated by a floor to ceiling wall are considered distinct indoor spaces for determining whether someone was in close contact with an infected party. And just narrowing down a little bit more on the infectious period. So that's defined differently for symptomatic versus asymptomatic cases. And the period will typically run from 2 days prior to the onset of symptoms. And for asymptomatic cases, it'll be 2 days prior to that positive test. And that will run through 10 days until after symptoms appeared, or 5 days after the individual tests negative. So to kind of circle back on Alicia's question that was asked, if someone was remote, maybe 1 day, you have to look 2 days prior to see if they were possibly in that infectious period for determining that close contact. So keep that in mind. So a couple of takeaways from that is, again, just be aware of any updates from the California Department of Public Health, as they provide a lot of guidance on masks and ventilation regulation. Make sure to include your COVID-19 as a workplace hazard now and move it into your written IIPP. And again, just continue to monitor COVID-19 cases, because if there is a major outbreak, you will have to report that to Cal OSHA, no longer the California Department of Public Health. And so now I'll pass it over to Corinne, and she'll discuss leaves, benefits, and accommodations.
Thanks, Alex. So let's talk about leave, something you all seem to be very concerned about. So hopefully after this, you won't be as nervous about it. So as of January 1st, 2023, eligible employees are entitled to up to 5 unpaid days of bereavement leave upon the death of a family member. This new law applies to private employers who have 5 or more employees, and that would include nonprofits as well. Employees are considered eligible if they have been employed by the employer for at least 30 days prior to the start of their leave. A family member means mostly immediate family, including a spouse, child, parent, sibling, or grandparent. And in the handout that we will send out after this presentation, there's a full list of all family members. Eligible employees must complete their leave within 3 months of the date of the death, but the days of bereavement leave do not have to be taken consecutively. Leave must be taken pursuant to an existing bereavement leave policy. If you do not have an existing policy, the bereavement leave may be unpaid. However, employees may use any leave balances available to them, including accrued sick leave. An employer may request that the employee provide documentation of the death of the family member within 30 days. The term documentation includes things like a death certificate or a published obituary. And again, the handout will provide more examples of documentation. Employers must maintain employee confidentiality and shall not disclose any documentation except to internal personnel or counsel. This law does not apply to an employee who is covered by a valid collective bargaining agreement that provides for at least the 5 unpaid days of bereavement leave. So takeaways for employers, if you have 5 or more employees, you should add a bereavement leave policy to your employee handbook and personnel policies, which is something that we here at Myers-Nave can help you with, and provide training to managers to ensure that they're aware of this new leave. Now let's talk about maybe the one that you're more concerned about, which is the CPRA paid sick leave. So as of January 1st, 2023, there was a significant change for California employers with respect to family and medical leave and paid sick leave. Employees can now identify a designated person for whom they want to use leave when they request either unpaid leave under the California Family Rights Act, also known as CPRA, or when they request paid sick leave under the Healthy Workplaces, Healthy Families Act, which I will refer to as paid sick leave or PSL. Under both amended laws, employers can limit an employee to 1 designated person per 12-month period. How each of these laws defines designated person, however, differs slightly. So we'll start with CPRA, which applies to private employers with 5 or more employees, again, including nonprofits. CPRA provides unpaid job protected leave to employees to care for family members who have a serious health condition. CPRA previously defined family member to include child, parent, parent-in-law, step-parent, grandparent, grandchild, sibling, spouse, or state registered domestic partner. Now the family member definition also has a designated person, which is defined as any individual related by blood or whose association with the employee is the equivalent of a family relationship. Unfortunately, the law does not define equivalent of a family relationship. You could think of possibly a brother-in-law. That's not someone related by blood. It's not someone who falls under the definition of family member, but that is probably would be considered a family equivalent relationship. Like with other family members, employers are able to request a healthcare certification for CPRA leave used for an employee's designated person. So with the ability to take leave for a designated person, some employers may be required to provide as much as 24 weeks of unpaid leave because of the Federal Family and Medical Leave Act, also known as FMLA. Next slide, please. Employers must provide FMLA leave if they employ more than 50 employees. This concept is best explained through an example. So if you have employee Corinne, employee Corinne's brother and maternal aunt each have a serious health condition. Corinne can choose her aunt as her designated person because they are related by blood. So in scenario 1, Corinne first takes leave to care for her aunt. Corinne could use up to 12 weeks of CPRA leave to care for her aunt as her designated person. Because her aunt is not an FMLA family member, those 12 weeks of leave would not count against Corinne's federal leave entitlement, meaning Corinne could then use up to 12 weeks of the FMLA to care for her brother. If the scenario is reversed though, and Corinne first takes leave to care for her brother, a sibling is a family member under FMLA. So under this scenario, Corinne's employer could double count that leave under both FMLA and CFRA so that Corinne would be unable to use an additional 12 weeks of leave to care for her aunt during that same 12-month period, excuse me. Now turning to paid sick leave. Under California's paid sick leave, employees can use sick leave to care for a family member, which previously was the same family members we already reviewed for CPRA. And paid sick leave in California applies to all employers, no matter how many employees you have. So now the paid sick leave definition of family member includes a designated person, which is defined as a person identified by the employee at the time the employee requests paid sick leave. So this definition is much broader than the CPRA definition because it does not require the person be related by blood or even have a family equivalent relationship. Subject to guidance from California's Labor Commissioner, a designated person for PSL purposes might include a roommate, a romantic partner, or a friend. Please see your handout that we'll send out after the presentation for information about local ordinances that provide additional sick leave coverage. Next slide, please. Lastly, the addition of a designated person also expands the ability to take kin care leave. Kin care leave only applies if an employer provides sick leave or paid time off beyond what is required under the paid sick leave law. If so, the kin care law requires an employee be allowed to use up to half of the employee's accrued paid time off to care for a family member. The definition of family member for kin care is the same as the paid sick leave definition, which now includes a designated person. And again, that definition does not require a blood or family type relationship. So takeaways for employers with this new designated person leave. Review and update your handbook and policies to reflect this new law. Again, we can help you with this. Prepare to handle and track the use of these leaves to care for a designated person, especially if FMLA applies to your business. And then monitor the websites of the Labor Commissioner and the Civil Rights Department, which we will touch on later, for forthcoming guidance and proposed rules. So now turning to a new law in California, SB 1044, which went into effect on January 1st of this year. This law prohibits an employer from taking or threatening adverse action against employees who refuse to report to or leave a workplace worksite due to a reasonable belief that the workplace or worksite is unsafe because of an emergency condition. The law defines an emergency condition as either one, conditions of disaster or extreme peril to the safety of persons or property at the workplace or worksite caused by natural forces or criminal act, or two, an order to evacuate the workplace, worksite, the worker's home, or the school of a worker's child due to natural disaster or criminal act. So some examples of this would be an earthquake or a school shooting. It's important to note that this law does not apply to health pandemics such as COVID-19. Through this law, it's now also unlawful for an employer to prevent employees from using their mobile device to seek emergency assistance, assess the safety of a situation, or communicate with a person to verify their safety if in such an emergency condition. This law does not apply to several types of first responders and employees who are required to work during an emergency. So please reference the handout for a complete list of these exceptions. One of the biggest takeaways here is for employers who may prohibit or limit employees' use of cell phones during work. If you have a policy like this, it's best to consult with counsel to ensure that your policy complies with SB 1044. And now I will turn it back to Alex.
Thanks, Corinne. So the Pregnant Workers Fairness Act is a new federal law that will be effective as of June 27th this year. And this law expands protections for pregnant workers by requiring employers to make reasonable accommodations to the known limitations related to pregnancy, childbirth, or related medical conditions. Now you're probably asking, what's a known limitation? And that is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions that the employee or someone who represents the employee actually communicates to the employer. So what does that mean for California employers? So California already requires employers to grant reasonable accommodations for these conditions through an interactive process if the employee is disabled by the pregnancy. So this new federal law actually makes it broader and applies to any of the known limitations, regardless of whether the condition meets the definition of a disability in the Americans with Disabilities Act. So practically speaking, so if an employee requests an accommodation based on that known limitation and communicates it to the employers must engage in an interactive process, again, even if it doesn't qualify as a disability. There is an exception to these requirements if it would impose an undue hardship on the employer's business operation. And again, those undue hardships vary from employer to employer, so please reach out for any additional guidance that you might need. Next, we have the Providing Urgent Maternal Protections for Nursing Mothers Act, or PUMP Act. So this act expands federal workplace protections for employees who need to express milk and will become effective April 28th this year. Again, California already requires employers to provide a reasonable amount of break time to an employee who needs to express milk, and in fact has stricter guidelines than the federal law that must be followed, which define what an adequate place to express milk is. Those will be included in the handout, but just some new requirements with this federal law are first, that the break time must be provided to employees to express milk who give birth to a stillborn child or a child whom the employee doesn't retain legal custody. So it isn't just limited to your child that you're taking care of. The second aspect of that is that the reasonable break time for express and milk is considered hours worked if the employee is not completely relieved from duty during the entirety of the break. So again, similar to already California rest breaks, meal breaks, no work can be done during those times. And lastly, some good news for employers that the employee must inform the employer if the failure to provide an adequate place to express milk gives you 10 days to come into compliance before the employee is allowed to bring action against the employer. So please be sure to reference the handout for a more detailed explanation of what California requires to ensure compliance. Now we'll move over to some workplace protections, specifically talking about privacy. So previously, employers were exempt from complying with the bulk of the California Consumer Privacy Act, or the CCPA. However, as of January 1st, the California Privacy Rights Act, the CPRA, amended the CCPA and expanded privacy and information security obligations for many employers doing business here in California. So we'll go step by step. The first step is knowing, does this even apply to your organization? So the CCPA applies to businesses that collect personal information. And this information is pretty broad. It's name, email address, social security, your physical address, other pieces of personally identifiable information. So if you have an employee, that qualifies because you're collecting their information. You have at least one employee in California. Now, the third part is whether the business satisfies one or more of the following criteria. And this is where you need to pay attention. So first, if the business has an annual gross revenue in excess of $25 million globally in the preceding calendar year. So that's one part. Another one is whether annually you buy, sell, or share the personal information of 100,000 or more people. Or the third part is whether you derive 50% or more of your annual revenue from selling or sharing collected personal information. So even if your company isn't in the data selling business, and if you have an annual gross revenue of $25 million more with one employee, this law is going to apply to you, but it will be limited to your California employees. Now you're probably thinking, I don't do anything with my employees' data. However, you have to consider any of your outside vendor agreements. So this could be insurance companies, payroll providers, or any other contracts you may have signed in order to run your business where you're required to share the data. Some of these are going to come into play. So what rights do your employees have? The complete list is in the handout, but some key ones to know are just the right to know what personal information is being collected by the business, the purpose of that collection, and if it's being sold to whom at the time that data is collected. Employees also have the right to delete personal information that is collected, subject to a few exceptions. They can opt out of the sale of personal information. A big one is that they have the right to initiate a private cause of action for any data breaches. So information security is vital for not only your consumers, but now it includes your employees as well. And of course, the right to limit the use and disclosure of that personal information. So in order to comply with these various requirements, employers are going to have to provide notice of these rights to your employees and obviously honor those rights. You're going to have to facilitate any requests that come in, such as a request to delete information or a request to opt out. And this could mean an overhaul of your IT security and your processes that you use to keep this information safe. If you don't comply with these new requirements, there is a fine. It can be up to $2,000 per violation. It can be $2,500 for a negligent violation or $7,500 for a willful violation, which means you just don't care and you're gonna keep on doing whatever you're doing. So what you need to do is determine what kind of information you're getting from employees, and not only employees, but applicants as well. Where it's being stored, how it's being disclosed or shared with those vendors, such as payroll, insurance. This is going to require you to prepare written policies, procedures to ensure compliance with specific disclosure requirements, such as annual privacy disclosures, creating a process of making requests and responding to those requests as well. This could also require just the preparation of an addendum for any existing contracts that you may have with your vendors to just expressly say, hey, you cannot sell this information from my employee and things of that nature. You're also going to have to provide training to staff who are going to be responsible for taking in those requests and responding to them in a timely fashion. And now we're moving on to arbitration. Arbitration agreements are one of the most recommended policies that we can give you to reduce frivolous litigation. However, California is very hostile to upholding the enforceability of these agreements. This is reflected in its most recent carve-out, although employers had a big win last summer with individual PAGA actions that Arlene will cover in just a minute. So the new one that was asked is the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And this allows a person who's alleging sexual assault or sexual harassment to void the arbitration agreement, even if it was previously enforceable. Otherwise, arbitration agreements are otherwise enforceable because this person can choose to void the agreement for their sexual assault or sexual harassment claim. They can bring that in either state or federal court. Meanwhile, any other claims that they might be included could still go to arbitration. So this just means that you would ultimately have something in state or federal court dealing with the sexual assault or sexual harassment claims while still arbitrating the additional claims through your regular arbitration agreement. So now I'll pass it over to Arlene to discuss PAGA.
Sure. So thank you, Alex. As Alex mentioned, we recommend that there be employment arbitration agreements for employers because it helps to reduce class action litigations and also keeps cases outside of the jury for discrimination claims. So we had a rare piece of good news in 2023 related to arbitration agreements, which was this case of Viking River Cruises versus Moriana, which allowed employers to enforce arbitration agreements related to PAGA claims. That's the Private Attorneys General Act. And that's something similar to a class action in that one individual employee is then asserting the claims of all the other employees. With the Supreme Court decision, employers can now use the arbitration agreement and push the individual claim of the employee into arbitration, leaving the representative part of the action still in court. According to the U.S. Supreme Court, that claim should be able to be dismissed because the individual plaintiff is no longer part of this case. But as we've seen, we have a number of these cases going through the trial courts right now, and a number of courts are kind of holding off to decide whether to dismiss those representative claims because there is a California Supreme Court decision that is still pending. So I think probably in 2023, we're going to see more, but this case just serves to underscore how important it is for you to have arbitration agreements for your employees. And if you haven't updated in a couple of years, we'd advise you to take a look at it just to make sure that it's still enforceable based on the most recent case law. So that's basically our takeaway. Oh, the other thing just to keep in mind is that AB 51 is still out there. That was the law that was supposed to go into effect in 2020, which banned mandatory arbitration. And that case has also been winding its way through the courts. We don't have a decision yet as to whether that's enforceable. So just keep in mind that things may be changing with arbitration agreements in 2023. And now we're going to move on to the next section with Neha, our labor expert.
Thank you, Arlene. So we're going to touch on the exciting world of labor relations in the private sector. And recently, I'm sure all of you have seen all the organizing at Trader Joe's, Starbucks, Pete's, Apple. These employers are on a growing list of employers that are navigating employee union organizing efforts. Apple workers in Townsend, Maryland voted to form a union, making them the first of the giant retailer to do so. And efforts are underway at Apple stores in Georgia and New York. Amazon workers unsuccessfully sought unionization in Alabama, but they did land a huge win at the Staten Island facility in New York. And they're actually on their way to landing another win at the San Bernardino facility in California. Starbucks is facing significant and speedy union campaigning efforts with employees at 54 stores in 19 states currently pursuing union elections. So the big question is why do employees unionize? Well, the biggest reason is dissatisfaction with how management treats employees, or at least the perception that management is treating employees poorly, coupled with the belief that the union can make the working conditions better. Pay and benefits are frequently at the top of the list for grievances, especially right now with rising inflation at an all-time high and wage increases just not keeping up with the cost of living standards. Insufficient staffing is another big one. And then at least at the Amazon warehouses where organizing efforts are occurring, substandard working conditions was highly cited as an issue. Well, what are some of the signs that employees are dissatisfied? One of the biggest signs is noticing that poor performing employees are suddenly feeling emboldened or acting emboldened, increased questioning about wages and benefits, groups of employees looking like they're hiding something, having secret conversations in the hallways, in the bathrooms, in the break rooms. And then also the use of union buzzwords. So words like, or phrases like terms and conditions of employment or right to representation, union steward, those are commonly used phrases in labor relations world. So what are some big takeaways for employers? Well, employers should address employee concerns early and consistently, and not just when organizing efforts commence. This requires fair treatment of all employees and ensuring proper documentation of policies and employment decisions, transparency, and providing well-established avenues to address worker grievances. And you also want to ensure that salary and fringe benefits are at the least consistent with industry standard and local cost of living. Employers should also have a dedicated employee relations team to continually audit working conditions for employees. That means like boots on the ground reviews of facilities and meeting with actual facility supervisors. And then supervisors should be promptly trained on workers' rights and conflict resolution. And once organizing efforts commence, employers, you just need to be careful not to disproportionately apply rules against employees engaging in organizing activity. You also want to make sure that your supervisors are fully trained and understand that they cannot communicate regarding union and union representation. Next slide, please. Along with the increasing organizing efforts, the current NLRB is definitely swinging more in favor of employee rights. The National Labor Relations Board, the NLRB, issued a decision in Troy Grove, which expanded Weingarten rights to non-union strike replacement workers. And for those of you unfamiliar with Weingarten rights essentially are the right to representation for unionized employees in an investigatory interview that may lead to discipline. So in this case, following the expiration of a collective bargaining agreement, union employees voted to strike. And the employer denied union representation to a strike worker employee who was undergoing an investigation for attendance issues, arguing that because employers do not have an obligation to bargain with the union over the terms and conditions of employment for replacement strike employees, that the rights to representation also do not attach to replacement strike employees. The NLRB disagreed with Troy Grove, stating that Weingarten rights are held by the employee and not the union. Thus, there is no attached bargaining obligation to be considered. So the big takeaway for employers from this decision is that non-union strike replacement employees now have Weingarten rights. They do have a right to union representation during an investigative interview that may lead to discipline. So should you receive that type of request for not just a strike replacement employee, but like a union adjacent employee, you should err on the side of caution and grant the request. Next slide, please. Moving on to equity in the workplace. So in the interest of time, I'm going to breeze by this a little bit, but the big takeaway here is that the California Department of Fair Employment and Housing, which is also known as the DFEH, was recently renamed to the California Civil Rights Department. So this is not a new government agency. All the Civil Rights Department still reflects all the same existing powers and authorities of the DFEH, and the rename was actually more to capture the services the department provides and hopefully increase public access to its services. But the takeaways for you are that you as the employer should ensure that you have updated versions of the Civil Rights Department required posters, guides, and fact sheets posted to reflect the new name, logo, and website. And then you should also update any handbooks or policies that make reference to the DFEH. Moving on to marijuana use, and this has been a popular one for employers. Currently, employers can effectively prohibit marijuana use on and off the job. However, beginning January 1st, 2024, AB 2188 will create anti-discrimination protections for employees who use marijuana off duty and away from the workplace. SB 2188 establishes a new category of employee protection under the California's Fair Employment and Housing Act, also known as FEHA. Once effective, employers will not be permitted to discriminate against employees based on their use of marijuana off the job and away from the workplace, or based on employer-required drug screenings that find non-psychoactive cannabis metabolites in the employee's hair, blood, urine, or other bodily fluid. These new protections apply to persons through hiring, termination, or any term or condition of employment. Employers can still enforce drug and alcohol-free workplace policies and may still test current employees if there is an individualized reasonable suspicion of impairment on the job. It's important to note that this legislation does not apply to employees in building or construction trades, or applicants or employees hired for positions requiring a federal government background investigation or security clearance. So this includes certain safety sensitive transportation employees that are hired through the Department of Transportation. So there's a lot of big takeaways for the employers for this legislation. And that's covered more in detail in the handout that you'll receive after this presentation, but just to highlight the big ones, employers should update their drug and alcohol-free workplace policies to be compliant with this legislation. This includes a policy specifically forbidding on-duty use of marijuana and defining what it means to be off the job and away from the workplace, which might have changed in this new remote hybrid world. So if necessary and applicable, you should also consider a separate detailed Department of Transportation drug and alcohol testing policy for those safety sensitive positions. The policies should set clear standards for when a reasonable suspicion exists to conduct drug tests and who can make the decision. And this is really crucial for reducing an employee's reasonable expectation of privacy in the workplace. You may need to reconsider the type of test used to test marijuana impairment. So Many blood and urine tests measure non-psychoactive marijuana chemicals that do not reflect current impairment and instead only reveal when the employee has consumed marijuana over an extended period of time. So you can coordinate with your testing provider to discuss which testing options are available and compliant with the legislation. At this time, we are aware of breathalyzer tests that might be available that only test for certain THC metabolites. You still have a full year to comply, and we can certainly help you navigate this, this legislation. We do have an employment law alert being released later this month, which will have even more detailed information about what to expect and how you can prepare. Next slide. So the Fourth Circuit recently affirmed that people who suffer from gender dysphoria may qualify for protections under the Americans with Disabilities Act. And gender dysphoria is when a person may feel that there is a mismatch between their biological sex and their gender identity. In this case, the U.S. Court of Appeals for the Fourth Circuit held that gender dysphoria is a disability suffered by many, but certainly not all transgender people. And that while being transgender is not a disability, the clinically significant distress felt by some transgender individuals may qualify for protections under the ADA. So California courts and the Ninth Circuit have yet to tackle whether gender dysphoria absolutely qualifies for protection under the ADA, but the Fourth Circuit's recognition that gender dysphoria is closely connected to transgender identity could mean that employers may be liable under the ADA if they fail to consider appropriate accommodations or fail to engage in the interactive process when a transgender employee presents a request to perform workplace activities or functions in accordance with their gender identity. So the big takeaway for employers are that managers and human resources staff need to be trained to recognize that transgender employees may not be discriminated against in the workplace, and that reasonable accommodations and an interactive process may be appropriate when a transgender employee presents a request to perform workplace activities or functions in accordance with their gender identity. And now I'm going to turn it over to Alex.
All right, thanks, Neha. To finish out equity in the workplace, the Sexual Abuse and Cover-Up Accountability Act provides additional time for victims of sexual assault to pursue legal claims by reviving two types of sexual assault claims. First, the adult sexual assault, but second is kind of the cover-up. And so previously that were barred due to statute of limitations, those claims that occurred on or after January 1st of 2009 now have until December 31st of 2026 to be filed. And that's just if they were barred due to a statute of limitations. Due to this increased time that victims can file a claim, it's important to retain any employee records of incidents involving sexual assault. And this could include any kind of wrongful termination or sexual harassment. And this is to ensure that you can defend yourself if accused of essentially covering up an assault. And for purposes of this new law, a cover-up means a concerted effort to hide evidence relating to sexual assault that incentivizes individuals to remain silent or prevent information relating to that behavior from being public or disclosed to the victim. And so a lot of times this would include the use of any kind of non-disclosure agreement or confidentiality agreement. So a big takeaway for this is making sure you review any kind of agreements that you have to include language that specifically states that the confidentiality provisions don't prevent employees from discussing the underlying facts of any kind of sexual assault in the workplace. Make sure you train your officers, directors, HR to avoid any kind of practice that would incentivize this type of silence. And of course, if you receive any kind of complaint of sexual assault, harassment, really any kind of complaint at all, prompt investigation is key, and ensuring accurate records and making sure you store those appropriately. And with that, I think we only have a minute. I don't know if we have any questions in the chat.
Yeah, thank you, Alex. I think we're gonna probably have to let people go for
Yeah.
the rest of their afternoon, but if you have any questions, please feel free to follow up with us. We will be sending a handout and the PowerPoint that we submitted with, there are actually even more issues that we couldn't fit into an hour in this very quick run through. So thanks so much for joining us, and we will see you soon.